in his life that something bad would happen to his children would come true. And then he can talk about how after that, and perhaps as a result of that, he has lived in fear. I think that was the offer of proof that Ms. Tish McGuire made. So I think that's appropriate. What I don't think is appropriate is to have him dwell on when this fear started, how it evolved, how it developed over the years, why did it develop over the years, how it affected him over the years. I don't think that's appropriate victim impact evidence. Does that make sense?
Yes, thank you, Your Honor.
All right. In terms of the other point that I said I would think about further, I am standing by my ruling. That's with respect to the grandparents.
For Chantal Blanc.
Right. It's with respect to Mr. Blanc's, Jonathan Blanc's grandparents. And the offer of proof indicating that they're battling cancer and they're having to do it without their grandson's help. If they had been diagnosed with cancer before the shooting, and if Jonathan Blanc had been helping them out with that before the shooting, I would come out different on this. But given that this is something that happened after the fact, I just don't think it's fair. I don't think it's appropriate. Victim impact evidence. It may well be that Jonathan Blanc would be helping them out, but we're speculating, or at least there would be speculation about that. Now, she can testify, and I'm referring to Chantal Blanc, about how she's helping them out with a lot of things because he's not there. So she's the one having to do it, and she helps them with health-related issues, with everyday things, whatever other things she's helping with that he, because he's not there. I think that's appropriate. So I'm standing by my ruling with respect to that issue.
Your Honor?
Yeah.
While we're talking about grandparents, we were looking at the statute last night, the court's proceeding under 24-4.1-302 for the definition of immediate family. And if the court is using that definition for family, we noted that it does not have in there grandparents or aunts, uncles, cousins. And so we wanted to ask the court whether the court was going to allow any impact on grandparents, since that is not included in that statute, in that definition.
Yes, I'm standing by my ruling in order P83B on pages 7 and 8, and specifically on page 8. And I think it goes on from there. Actually, it may go on to page 9. The statute at one point uses family, and at another point uses immediate family. And I don't read the statute as meaning that it is limited to immediate family members. I think the statute should be read as including any family members. And so at a minimum, immediate family members are included, and that would include a significant other. But it's not limited to that. It goes beyond that. And so I'm standing by my ruling in order P83B.
And our objection is on the record from our motion.
Yes, you put your objection in the response, and I disagreed with your interpretation of the statute. While on the topic of significant other, I said that I would allow evidence related to the impact that the crimes have had on victims' significant others. And I think there are 3 or 4 that have been identified. And I indicated to Ms. Tish McGuire that the people would have to establish the appropriate foundation. In other words, they would have to establish that the person who was impacted is truly a significant other. There is a definition of significant other in Colorado Revised Statute, section 24-4.1-302, and it's as follows, and it's subsection 4. Significant other means any person who is in a family-type living arrangement with a victim and who would constitute a spouse of the victim if the victim and such person were married. So that's the foundation that I will be requiring. There was an objection, or actually there was a comment, not an objection, there was a comment as to hearsay yesterday by Ms. Higgs. And I thought more about this. I'm not ruling on anything right now because there hasn't been a specific objection, and I indicated that I would allow Ms. Hicks to object whenever she deems appropriate. But, there is some of this victim impact evidence that will necessarily include out-of-court statements. The law allows victim impact evidence, for example, that includes how a witness found out that the victim was dead or that the victim had not survived, or, for example, the last contact the witness had with a victim. There are some, or for example, what may have been said in a memorial or in a funeral that goes to the unique characteristics of the victim and indirectly also to the impact on the community, which is what Payne talks about, P-A-Y-N-E, the loss to the community or the loss to society, if you will. So I just throw that out there. There is some of this that necessarily will include out-of-court statements. So keep that in mind as you make any objections. You should make them in the context of understanding that the law allows for this type of victim impact evidence. I took under advisement some photographs and the objections to those photographs. And there was a category of photographs that included grave sites or tombstones or caskets. And the people are intending to introduce those photographs. The defense is objecting. And they relate to different victims in this case. And I think that the case that people have cited in the past in their written filings is People versus Brady, which is 236 Pacific 3rd, 312. That's a California case from 2010. There appears to be a split of authority on the issue, and the Brady court acknowledged as much. It cited to a case from Missouri, which is State versus Story, S-T-O-R-E-Y. That's a Missouri case from 2001, 40 South Western 3rd, 898. In which the admission of a photograph of the victim's tombstone was found to be improper, but the court eventually concluded that the error was harmless. The Brady court also cited to Welch versus State. That's a case from the Oklahoma Criminal Court of Appeals from 2002, Pacific 3rd, 356, where the court found that the admission of testimony about placing flowers on the victim's grave was error, but that the error was harmless. California does not prohibit such evidence as indicated in Brady. I looked at Story versus Roper, and I also found, or State versus Story, and then I also found Story versus Roper, which is a related case from the 8th Circuit Court of Appeals, 603 Fed 3rd, 507. That's an 8th Circuit Court case from 2010. And I think this was a habeas proceeding that the defendant had taken from the Missouri decision, the Missouri Supreme Court decision, and the defendant again would be Mr. Story, S-T-O-R-E-Y. And here's a discussion that I find instructive from that case. It says in Payne, and it's referring to the United States Supreme Court decision in Payne 501 U.S. 808. The Supreme Court considered the admissibility of penalty phase testimony by the mother of a deceased victim. The woman testified about the effect of the crime on her surviving young grandson who had witnessed the murder of his mother and baby sister and had himself nearly been killed by the same attack. The court held that the Eighth Amendment does not erect a per se bar to relevant victim impact evidence or prosecutorial argument on the subject. The court held that the victim's mother's testimony was admissible, noting that similar to the defendant's right to present evidence in mitigation during the penalty phase, the state has a legitimate interest in reminding the sentencer that just as the murderer should be considered as an individual, so the victim is an individual whose death represents a unique loss to society, and in particular to her family. That's the language that Ms. Teach McGuire quoted last night when we were having the discussion. The court in Story, the Eighth Circuit went on to say, the state does not have unfettered discretion to offer such evidence, however. If a witness or remark in a particular case so infects the sentencing proceeding so as to render it fundamentally unfair, the defendant may seek relief under the Due Process Clause of the 14th Amendment. In a concurring opinion, Justice O'Connor found the allegedly offending evidence survived the due process analysis because the evidence was brief and redundant of evidence already admitted during the guilt phase. The court went on to say, with regard to Claim 9, the Missouri Supreme Court first set forth the governing law that victim impact evidence is admissible under the Missouri and federal constitutions, and that the state is allowed to present evidence showing each victim's uniqueness as an individual human being. The court quoted Payne and found that victim impact evidence violates the Constitution only if it is so unduly prejudicial that it renders the trial fundamentally unfair. With regard to the exhibits, the court found that all but one, the photograph of the tombstone, were properly admitted because they showed the victim's uniqueness as a human being. The photograph of the tombstone was improper, it said, but was not so unduly prejudicial as to render the trial fundamentally unfair. Payne offers very little specific guidance about the permissible extent and content of victim impact evidence. The evidence should show the victim's uniqueness as an individual and the resulting loss to society. The evidence must be relevant and not so unfairly prejudicial as to infect the sentencing proceeding and render it fundamentally unfair. Decided in 1991, Payne is the Supreme Court's last word on victim impact evidence. Without more guidance, it is exceedingly difficult to find that a particular state court's decision is contrary to or an unreasonable application of the court's clearly established victim impact jurisprudence. As the Supreme Court lengthens its silence on the issue, it seems that prosecutors, likely of both the state and federal variety, will continue to push the envelope with this type of evidence. At oral argument, counsel for the state audaciously stated that the state knows what the line is and presumably does not cross it with excessive displays of victim impact evidence. With all due respect, we could not disagree more. As evidenced by the 3 penalty phase trials in this case alone, 2 of which were reversed and remanded for a new trial based in whole or in part upon improper prosecutorial argument, the line is barely decipherable and rarely sacrosanct in these highly charged emotional death penalty trials. Nonetheless, under our extremely deferential standard of review, the Missouri Supreme Court's conclusion that all of the exhibits save the picture of the tombstone likely fell within the vague ambit of permissible Payne evidence was not contrary to nor an unreasonable application of Payne. And while the picture of the tombstone was improper, the Missouri court reasonably concluded that in light of all the relevant and admissible evidence presented at the 3rd penalty phase trial, the photo of the tombstone did not render the penalty phase trial fundamentally unfair. So, after reading that part of the decision in Story versus Roper, after reading part of the decision in State versus Story, and after reading part of the decision in Brady, I'm going to keep those pictures out. I think that whatever probative value those photographs have is substantially outweighed by the danger for unfair prejudice. So the defense's request to exclude them is granted. Now, I have allowed testimony with respect to funerals and memorials, but of course, you can't present that. You're doing that. I'm just having a conversation. The, the probative value of that testimony is so that a full and accurate picture of the victim can be presented. To the extent that there is any information in the funerals held or memorials held that goes to the uniqueness of the victim, to the characteristics of the victim, then I think it's proper. And I think that is victim impact evidence that the law allows. But it can't just be the kind of thing that's just being presented for its emotional or dramatic effect, obviously. So I'm drawing a distinction. The pictures, I just don't see a whole lot of probative value. Everybody understands that all of these 12 victims are deceased. Everybody understands that they have died. There's going to be testimony related to the impact that the crimes have had on the surviving family members, and showing a picture of the family members near a casket or near a tombstone, or showing just a picture of a gravesite doesn't add a whole lot. So for those reasons, I'm keeping those pictures out. There were objections to other photographs, and so let me address those objections at this time. In terms of Alex Teves, I believe that there are 10 total photographs. Is that right, Ms. McGuire?
Sure.
Okay. I don't think that's improper. I don't think that that's excessive. I don't think that's cumulative. And I'm also not concerned about the fact that 5 of those pictures include Amanda. Tell me her last name again and spell it, please.
Teves, Teves. Her maiden name was Lindgren, Lindgren.
All right, thank you. Yesterday you used her maiden name, and that's why I was asking. All right, Amanda Teves. Yes, she has testified in this trial, and yes, she was a survivor of the shooting, but she didn't have serious injuries. I don't see what prejudice there is from having her included in some of the photographs, and the 5 photographs that were objected to by Ms. Hicks yesterday are photographs that appear to show different events in Alex Teves' life. So the objection to those pictures, 5 pictures, is overruled. That's pictures 2655, 4679, 4680, 4682, 4683. I don't have any concern at all that the jury is going to be confused, that somehow they can take into account whatever happened to Ms. Teves as opposed to Alex Teves. I think the jury is very clear on the 24 counts that are before it and what the issues are that are before it. I have been giving them instructions throughout. I will give them final instructions at the end of this phase as well. And I have no doubt that they will understand and that they will not be confused. And I'm not concerned that prejudice as a result of Amanda Teves being shown in some of the photos. Next there's one photograph that is objected to with respect to A.J. Boyk. There were actually 3, but the prosecution withdrew its intent to present 2 of them, so we're left with 1. That's 4673. And it is true that I have allowed already 27 photographs of A.J. Boyk, but apparently picture 4673 is the only one that shows him with his brother. So I think it's appropriate, and the objection as to that picture and being cumulative is overruled. 28 photographs is not excessive, especially given the case law that I have discussed in the order that I issued. Does anybody remember what the order was that I issued on this particular topic? I'm talking about the order that I issued that require the people to make some modifications to the videos and each montage. The people.
I'll find it for you, Your Honor.
Thank you. The people are intending to present. Thank you. If you would do that, please, just so that the record is clear. Next, I have a couple of pictures related to Jessica Gowie. The objection is to photographs 4689 and 4686. And the objection is that they are cumulative of the interview video that the people intend to present over. First of all, these are photographs, not videos. And second, I don't think that they are cumulative. These are not pictures of the same event shown or depicted in the video. These are pictures showing her in a different location, in different situations. And it goes to, again, allowing the people to present evidence to show the jury who Jessica Gowie was and to tell the jury a little bit about her life. So the objection as to cumulative with respect to those two photographs is overruled as well.
Your Honor, it was C-204.
C-204, thank you. And by the way, on all these cumulative objections I'm overruling, I'm finding that the probative value of the evidence is not substantially outweighed by the unnecessary presentation of cumulative evidence pursuant to Rule 403 of the Colorado Rules of Evidence. Next I have Jonathan Blanc, and there are 8 total pictures of Jonathan Blanc that the prosecution intends to present. That includes the one that has already been admitted. So really 7 additional photographs that the prosecution intends to admit during the phase 3 of the sentencing hearing. And again, I've looked at these photographs and I find that they're not cumulative. That's photographs 4695, 4696, 4691, 4692, 4693, 4694. Those pictures are not cumulative. I am excluding 4698 because that's a picture of his gravesite that shows his wife and children at his wife's gravesite. So actually, it's going to be a total of 6 pictures that the people are introducing in phase 3 with respect to Jonathan Blanc. That is by no means excessive, and the probative value of the photographs is not substantially outweighed by the needless or unnecessary presentation of cumulative evidence. Next, I have Matt McQuinn. There's an objection as to pictures 4702 and 4703, and these are pictures of a tombstone and picture of a casket, and so those pictures are out pursuant to my ruling. The other 4 pictures of Matt McQuinn that the defense is objecting to are 4699, 4707, 4706, and 4707, and the objection is that they're cumulative. Again, these appear to depict different moments in his life, and in my view, those 4 photographs are not excessive and they're not cumulative, so the probative value of the evidence is not substantially outweighed by the unnecessary presentation of cumulative evidence. Next, I have Gordon Cowden. The people withdrew the 2 additional pictures they were intending to introduce with respect to him. So the objections are moot. There are 29 pictures in a montage that the people intend to introduce with respect to Gordon Cowden. And I've already ruled on that pursuant to C-204. Actually, C-204 required the people to make some modifications with respect to that montage. Next, I have Jesse Childress. The objection is with respect to photographs 4719, 4720, 4721, 4722, and 4723, and the objection is that the defense couldn't tell how old he was in those pictures. In order C-204, I had indicated that pictures should be limited to about 18 months before the shooting. In other words, the people shouldn't be allowed to introduce pictures of the victims when they were children. That's pursuant to the case law. Here, the people indicated yesterday that these photographs show Jesse Childress when he was 24. He died when he was 29. And the reason that people are intending to introduce these particular photographs is to show his career in the military. I'm going to allow these photographs. I don't see a whole lot of difference between someone when he's 24 and someone when he's 29. I can understand the case law's concern about showing pictures of someone when they're a little kid, for example, celebrating Christmas, even though they died as an adult, or even pictures of someone when he or she was 16 or 17, even though he or she may have turned into adulthood by the time of the murder. But here we're talking about difference between mid-20s and late 20s, and the people are doing it for a valid purpose, and that is to show an aspect of Jesse Childress' life, and that is his career in the military. So the objection as to those pictures is overruled. To the extent that there was an objection as to cumulative, that too is overruled, because I find that the people are not attempting to introduce a lot of pictures with respect to Jesse Childress, only a handful, and the probability value of the evidence is not substantially outweighed by the unnecessary presentation of cumulative evidence. The next objections I have are with respect to Veronica Mosher Sullivan. There's an objection with respect to pictures 4730 and 4731 and 4732. So 3 pictures. And I think the objection is under Rule 401 and Rule 403, and also as included in Rule 403 is cumulative. And I disagree. I don't believe that these are cumulative. One of these has already been admitted. 4731 has been admitted previously. Am I right about that?
I was just going to pull it up, Your Honor. So that's the one that was admitted.
So you're intending to introduce 2 additional pictures of her?
That's all.
Okay, and I don't think that's excessive by any means. I think that actually shows self-restraint by the people, and I think that's appropriate. That's exactly what is expected of them. And the probability value of these 2 additional pictures is not substantially outweighed by the danger for unfair prejudice, or by the unnecessary presentation of cumulative evidence, or by any of the other concerns in Rule 403. There's an objection to 4851, and that apparently is a picture of Veronica Mosher Sullivan's gravestone, and I have ruled on that. That's out. There's no montage of Veronica Mosher Sullivan. There's a video, but not a montage of photographs, right?
Yes, Your Honor.
Okay, so my comments are accurate, and they remain. Yesterday, when I was having a discussion with the parties about this evidence, I talked about the balance that I have to strike. And I talked about the concern, on the one hand, to make sure that the jury is not overpowered with emotion or overwhelmed with emotion, so as to run the risk that the jury will make a decision based on emotion as opposed to reasonable judgment. On the other hand, I also said that the people have the right to present victim impact evidence, and they're entitled to show the magnitude of the crime and the harm that the crimes caused. And I read a moment ago from the Eighth Circuit decision in Roper versus Story, which focused on the dangers of victim impact evidence and how prosecutors sometimes, or perhaps oftentimes, get too aggressive with that kind of evidence, in part because there's not a clear line as to how far you can go or what specifically may be admitted. Let me now read from United States versus McVeigh, which presents the other side of the coin, and that's 153 Fed 3rd, 1166, 10th Circuit Court of Appeals from 1998. Here's what the court said. Taken as a whole, this evidence is poignant and emotional. The question before us then is whether allowing such a substantial amount of victim impact testimony reflecting the magnitude of such a large-scale crime violates the limits on such testimony set forth in Payne. Again, that's P-A-Y-N-E. We conclude that it does not. Payne allows the introduction of victim impact evidence in order to allow the jury to understand the consequences of the crime committed. The bombing of the Murray building was the deadliest act of domestic terrorism in the history of the United States. The magnitude of the crime cannot be ignored. It would be fundamentally unfair to shield a defendant from testimony describing the full effects of his deeds simply because he committed such an outrageous crime. The sheer number of actual victims and the horrific things done to them necessarily allows for the introduction of a greater amount of victim impact testimony in order for the government to show the harm caused by the crime. In addition, the jury could not have been shocked to learn that some victims had exemplary backgrounds and poignant family relationships, nor that they left behind grief-stricken loved ones. That's just an excerpt from the decision. It just shows you both sides of the equation, and my job is to strike the appropriate balance between the two. So on the one hand, the people are allowed to introduce victim impact evidence that fairly depicts the individual characteristics of the victim and the impact of the crimes on their family members. On the other, the people are not allowed to present such evidence that is so inflammatory that it will overcome the jurors and it will render the proceedings unfair. So the people have to show self-restraint. I've said it before, I'll say it again. It takes a great amount of self-discipline, but that's what the law requires. So, all right, Ms. Brady, do you have something?
I do. Your Honor, we would also object to statements about the victim's plans for the future. And the case that we would cite for Lockett versus State, 53 Pacific 3rd, 418, an Oklahoma appellate decision from 2002.
Tell me that site again.
Sure, 53 Pacific 3rd, 418.
Okay, I haven't read that case, so I'll have to look it up. Anything from the people, Ms. Tisch-McGuire?
Yes, Your Honor, we would cite to United States v. McVeigh, 153 F. 3rd, 1166 at 1219 through 21, which is a 10th Circuit case from 1998.
Okay.
And
I'll take a break and I'll take a look at both of those cases.
And I
Ms.
apologize.
Tisch-McGuire?
I just wanted to make another record, Your Honor, if the court permit me.
Yes.
Regarding the court's recommendation or order that the people only call a second family member until the very end, I just wanted to know if I could make an offer of proof to the court right now about what those second victims would testify to. I see two problems potentially with that request from the court. One is that I have certain evidence that I was going to introduce through one of the family members and not the other. And so if the court's not going to permit the second victim to testify, then the people would potentially introduce that evidence through the first witness. The second is that we planned today to have enough witnesses here who are in Colorado. And some of that would have been two family members today. And so I'm worried that we potentially wouldn't have enough witnesses here today for the court. So if the court would permit me to give you an offer of proof of what the second family member would testify to, I don't know if that would assist the court at all. It would be very brief, Your Honor.
It would. Let me tell you what my concern is. My concern is that part of my job is to assess how emotional the evidence is and what effect it's having on the jury. As you know, in the McVeigh trial, at some point the prosecution stopped. And if I allow you to call the two witnesses per victim that you want to call, we may get to a point, I'm just saying it's possible, where I say, I have to stop. And then what that's going to do is there are going to be some victims who are not going to have any testimony presented about them. I would rather have a second witness with respect to a victim excluded than have to exclude a witness going to testify about a victim that there has been no testimony on. So
And I appreciate the court's concern, and I realize that 168 victims were murdered in the McVeigh case, but they also presented 39 victim impact witnesses when they stopped as the prosecution, and we're requesting 16.
But it's not a numbers proposition either. I mean, it's not just strictly numbers. It depends on the nature of the evidence. And I know some of the evidence that was introduced in the McVeigh trial, and I know how emotional some of that evidence was. But you're familiar with the case. You also know that at one point the defense objected to certain evidence. And the court said, yeah, I'm having a concern too about all this evidence related to the last kiss and the last contact and about how they found out that their loved one was dead. And the prosecution said, Judge, we'll stop presenting that type of evidence. We'll keep it to something else. So, again, it's a fluid process, and my job is to make sure that the proceedings are fair, and I don't know what kind of evidence will be presented exactly. I mean, I know in general, but I don't know what effect, how emotional it will be. I don't know exactly what effect it will have on the jury. I'm going to have to be assessing that throughout, and you run the risk. I'm not going to tell you how to put on your case. I'm just telling you, if you do it the way you want to do it, you might run the risk that I exclude people that have testimony about victims that there has been no evidence about. So if you want to run that risk, if you're okay with that risk, then I'll let you proceed in that fashion.
And Your Honor, just so the record would reflect, the people would intend for Kathleen Larimer, who is John Larimer's mother, to testify about his entire life, and for Nora Wilwert, his sister, to only testify about his siblings and her relationship with John as the uncle to her children, which Kathleen Larimer would then not talk about all his siblings or talk about his relationship as an uncle to his nieces and nephews. For Ashley Mosier, she would talk about Veronica's life as Veronica's mother, and Robert Sullivan would be called to testify really for one main event, which is Veronica's kindergarten graduation, which Ashley could not be present at because her father's funeral was held the day of Veronica Mosier Sullivan's kindergarten graduation. And the video that the people intended to introduce about Veronica would also come in through Robert Sullivan, because that was her last Christmas, which was actually at Robert Sullivan's house. As to Alex Sullivan, his father, Tom Sullivan, would testify about Alex Sullivan's whole life, but also the people intending on calling his wife, his widow, Cassie Sullivan, to just testify about their marriage and their relationship only, but not any of his early life. And then the people intended on calling Robert Wingo to talk about Rebecca Wingo's marriage to him and to her children, her young children, but that's it, to talk about those two things, and then also to call Rebecca Wingo's mother to talk about her life as an offer of proof.
All right. Does the defense have anything at this time with respect to that?
Your Honor, I guess I would agree with how the court analyzed it to begin with. If there's a witness who can describe it all and we can get all of the information in one witness, I think the best practice would be to have one witness. If that's not possible, then obviously they can ask to call a second one, but I guess I would ask the court to stick with its original plan and after one witness see if it thinks it's necessary to have the second witness testify.
All right. Ms. Tisch-McGuire, given that I'm just bringing this up on you today on the morning of the testimony, I'm going to let you proceed as you wish. But again, my job is to assess how things are going, and if at some point I need to stop, then I will. And by the way, just so that it's clear, because we have to have a sentencing hearing that's separate from this. After these proceedings in front of the jury are over, I have to sentence the defendant on the other counts, and I have to enter formally whatever sentence the jury decides on these counts that are before the jury. If there are any victims, any witnesses that end up not testifying or that want to testify about things that I have excluded from the proceedings in front of the jury, I will allow them to speak to the court at that hearing. In fact, I will allow them to speak at that hearing regardless if they want to. I said before that I would not place any limits on who you call or how many people you call or how long the hearing takes. And that goes for both sides. Whoever wants to come in and testify, even if they, or speak, even if they may have testified during the proceedings, I will allow them to do that. And as I said before, if it takes a couple of days, if it takes 3 days, if it takes a week, we'll take however long it takes. So just because I'm excluding certain things right now doesn't mean that they will not ever be able to speak about them to the court. Does that make sense?
It does, Your Honor, and the people appreciate how generous the court is at the sentencing hearing. It's just that the reason in the case law for victim impact statements is that it could potentially affect the sentence. And unfortunately, in this case, at the sentencing hearing, the sentence will have already been decided. Thank you, Your Honor.
I understand. But the case law also says that victim impact evidence can affect the defendant's right to a fair proceeding, and the court has to be extremely careful with it because it has such potential to evoke such strong emotions. And that's what the case law is, and it is that for a reason. And I think you understand that. So again, the people have to exercise self-restraint. The more, and it's not easy, and it takes an incredible amount of self-discipline. But the more you do that, the better chances you have that I will not be saying at some point, we have to stop. So, okay? All right, I'm going to step down. I'm going to read these two cases, and then we'll proceed. The court will be in recess. Thank you.
Please rise.